All right, I'm going to call this special meeting of the Georgia Government Transparency and Campaign Finance Commission to order. Today is Thursday, May 12, 2022. It's 10 o'clock a.m. We've got an agenda that's been posted, that's also been provided to all of the commission members. Is there any discussion or any changes that need to be made with respect to the agenda?
Delay from my screen.
Hearing none, we will go ahead and proceed. Item number 2 on the agenda is election of a new commission vice chair. For those of you that didn't know, you can obviously see today that former vice chair Eric Barnum's term ended, and the governor appointed David Burge to fill that spot on the commission. It's my understanding that he has been sworn in at this point, so he's officially a member of the commission. David, I don't want to put you on the spot at your very first meeting, but if you want to introduce yourself and let some folks know anything about you, go right ahead.
Sure.
Sorry, let me make sure I get your... There you go.
I am another lawyer joining this commission. I do not practice election law. I'm a corporate real estate lawyer, but I did spend 6 years as a member of the Fulton County Election Board, where I learned a whole lot about the nuts and bolts and challenges of running elections, and I think that's what sort of led me over here. The two things I really learned over at Fulton County was how important public confidence in elections is, and also how fragile that confidence is. So my promise to my fellow commission members and the public is I will do everything I can to keep that confidence strong, because it's fragile, and we've got a lot of work to do there. But I'm honored the governor sent me over here. It's been kind of a whirlwind. I was just sworn in by Judge Richardson about an hour ago, so ready to go. Thank you.
Well, again, welcome. So we do have a new business that we need to take care of with respect to an election of vice chair. The way that, and again, I'm not saying that the commission has always done this, and I'm not saying that this is necessarily the way that the commission has to do it, but the way that it has worked, I guess recently, is that the individual with the most seniority would take the vice chair position at this point. I've been working with Commissioner Watts now for quite some time, and I believe he has the most seniority on the commission at this point among the other members. So I would make a motion at this point to nominate Commissioner Watts for vice chair.
I'll second the motion.
All right. We've got a motion and a second. Is there any discussion? Commissioner Watts, do you want to reject that?
No, I would abstain from the vote.
All right. Hearing no further comments, I'll call the vote. All in favor say aye. Aye. Any opposed? All right. Congratulations, Commissioner Watts. You will now be vice chair.
Do you want to change chairs? No. I like being down here.
He just demands a new plaque immediately.
All right. We will move to item 3 on the agenda. We are scheduled today for a final hearing in the following case. It's 2017-0169 PC in the matter of John W. Oxendine. I believe that some of us know that as Oxendine 2. Are we prepared to go forward with the final hearing, or do we have announcements?
We're prepared.
We're prepared. All right. Commissioner Watts, do you have something you would like to present to the commission with regard to that hearing?
Yes, sir. And we have a proposed consent.
Sorry. Which one is it? I said, I'm sorry. Mr. Lane, do you have anything you would like to announce with regard to this case? I'm sorry.
Yes, sir. The parties in this case have reached a consent order that we
What number is your mic?
It's going to say podium on the mic control.
Gotcha.
Okay. Commissioners, the parties have reached an agreement for a consent order that we'd like to present the terms to the commission for adoption.
Okay.
Which becomes the final order in Oxendine number 2.
Okay.
Okay. Commissioners, this case began in 2017. As the chair has denoted, it is the Oxendine 2 case. The first Oxendine case began in 2009 and has since been disposed of. It is no longer an active case. However, in this active case, the case came about After the commission was made aware of a number of discrepancies contained within Mr. Oxendine's supplemental campaign contribution disclosure reports, we noticed through a preliminary audit that several $100,000 had disappeared out of the respondent's campaign contribution disclosures. At that point, the commission instituted this case and issued subpoenas to begin the collection of bank records and other financial records. The parties engaged after that point in substantial litigation, going from before this commission on motions to quash. We went to the Fulton County Superior Court, we went to the Court of Appeals, the Supreme Court, and ultimately the Federal District Court for the Northern District of Georgia. Ultimately, the subpoenas were enforced. We obtained the bank records, and after obtaining the bank records, we had a preliminary hearing in front of this commission where we presented evidence that Mr. Oxendine had used funds for what we alleged were conversion of campaign funds for personal assets. We alleged that he had used funds for the down payment of the purchase of real estate, for the maintenance of automobiles, joining of private membership clubs, tuition for private day schools for a minor child. After this commission had held its preliminary hearing and found probable cause, the case was then referred to the Office of State Administrative Hearings to have a final hearing. That preliminary hearing occurred in 2019. The OSA hearing was unfortunately delayed due to COVID and other matters. There was an unreasonable amount of time for delay, and in 2001, Mr. Oxendine filed a motion to dismiss on the basis of that delay. At the Office of State Administrative Hearings, the administrative law judge granted that motion to dismiss. Sure.
Robert, if I may.
Yeah.
That motion to dismiss was filed in 2021, right?
Correct.
Not 2001.
You said
Sorry, 2021.
21, okay.
August 2nd of 2021. After the granting of that motion to dismiss, the case came back before the commission, and the commission reinstated the charges, overturning the decision of the administrative law judge, which is the commission's power to do. Subsequent to that decision by the commission, Mr. Oxendine has again appealed that decision to the Fulton County Superior Court. The parties have agreed that in lieu of continuing litigation, which based on current trends and track records will last for approximately another 2 to 3 years before we'd be able to have a final hearing in this case. What we have agreed is that Mr. Oxendine will be transferring and surrendering his remaining campaign funds that are in the campaign account to the state, and those funds will be transferred for deposit into the state's general treasury fund. As of April 11th, 2022, Mr. Oxendine has certified that the remaining campaign fund balance is $132,500. The parties have agreed that after the April 11th certified fund balance, Mr. Oxendine can expend no more than $5,000 additional campaign funds. That takes the balance to no lower than $127,500 for final expenses for the payment of outstanding legal fees, for expenses in wrapping up campaign disclosures, filing the final report and termination statement. And then after those expenses have been made, the final remaining campaign funds will be transferred to the state at the expiration of 30 days from the entry of this consent order. Once that is done, the commission will consider this case closed and dismissed with prejudice. No further actions will be taken against Mr. Oxendine in relation to his 2010 campaign for governor. And Mr. Oxendine will dismiss with prejudice his outstanding suit in the Fulton County Superior Court, which is currently stayed, I believe, by consent of the parties. And that's the terms of the consent order that we have today.
Okay. Before we entertain comments and questions, I'm going to ask Mr. Chalmers or Mr. Lonowitz if they want to make any comments at this time.
Thank you, Mr. Chairman. I'll be brief. I don't have much to add to what Mr. Lane said. I want to compliment Mr. Lane. He's a tough and he's a good lawyer, and I think that he came up with this proposal, and I think it's a good one, which ends up resolving the 2010 gubernatorial election, which I think is time to end. And our client is willing to comply with the terms. One quick correction on the dollar amounts. In the certification, we certified that it was approximately $132,500 prior to April 11th. It was actually $132,000, about $150, so a difference of about $350. We were allowed to spend up to $5,000 after April 11th. We've spent $4,000 and we're done. And so I think the total dollar amount of the check will be approximately $128,000. Thank you, sir.
Okay. Among the commissioners, is there any discussion before we entertain any type of motion with respect to the proposed consent order? Well, I'll make a comment then, since we didn't hear anything further. Dealing, in my career in civil cases, I had a mediator tell me one time very early, that's something that I've always remembered, that whenever there's a resolution of a case like this that's gone on for quite some time, when everything is said and done and over, you know that you've reached the right point when both sides really don't agree with what the result is. There's probably people out there that think that we should collect more, and I'm sure that Mr. Oxendine and his counsel, they don't believe that they should be having to actually give up funds that exceed $130,000. But I would say to y'all, I would appreciate the fact that both sides were willing to get together and try to hammer this thing out. So again, I don't know if there are any other comments from any commissioners before I entertain a motion or questions. Mr. Thompson.
So it's my understanding that this isn't even a penalty. Is that true? That isn't even a fine. It's just basically turning over whatever is left to make everything go away.
That is correct. It is a surrender of funds that will be transferred to the state treasury for deposit into the general fund, which is the same place where a civil penalty would go.
I think on my part, being a former regulator, sitting on here as a commissioner now, is that I understand this has been going on for a very long time, and I agree that it needs to be resolved some way. I do feel it's somewhat frustrating that there's no admission of wrongdoing, and we're not even calling this a penalty. And I understand that's part of the negotiations, and I understand Mr. Chalmers is good at that, and this is why we're here. But I just wanted to put those comments for me on record.
Mr. Ahmad.
And I appreciate those comments, Commissioner Thompson. To sort of explain the rationale from the commission standpoint in agreeing to enter this consent order, this settlement, I think, and Mr. Lane, obviously has been involved in this case much longer than I have, but the goals, I think, in a unique case like this that has drug on as long as it has, there are a few goals. I think once we became aware of the activity, we wanted to expose that activity and shine some light on it, and we've done that. The public's aware of that. They can do what they will with that information, but it is now public information. I agree with Commissioner Thompson. In an ideal world, from the commission standpoint, we'd get everything we want. But weighing the other issues at play here, I think the reality is, if part of our goal is to collect money as a result of this case because of those actions, whatever you want to call it, a penalty, whatever. The reality is, if we continued this litigation for another 2 or 3 years, the campaign fund would be drained in legal fees. And any award we would collect would have to be, effectively, my understanding is Mr. Oxendine now lives in Florida. So we'd have to hire outside counsel to attempt to garnish assets out of state, which would take several more years, would cost the state taxpayers a significant amount of money. And I think when you weigh all those issues against each other, I think this is the best available option that we have. And that's the rationale and reasoning in our agreeing to this consent order that we agreed to today.
I also want to add a couple of things about this matter that, and you guys correct me if I'm wrong, if we had a hearing today, a final hearing today, and let's assume that Mr. Oxendine's had at that point, at the conclusion of the hearing, $132,000 that remained in his campaign account. If we imposed a penalty on him that time, that would be paid out of that campaign account.
That is correct.
As long as it still existed at that point. I understand that we may be down the road to some degree, and legal fees and expenses and whatnot may be reduced from that. But again, in the world where if we had a hearing today, we imposed a certain fine or penalty, that would be paid out of the money that's actually being sacrificed.
You are correct, Mr. Chairman. The Campaign Finance Act is drafted to allow campaign funds to be used to pay civil penalties and late fees to this commission.
Okay. The other thing that I would say with respect to the fact that this consent order being different than consent orders that we do at the time of our preliminary hearing, in my mind, there's a great distinction between that. I think that at the time of a preliminary hearing, there's a resolution because there's going to be a question as to whether there are reasonable grounds to find that a person has violated the act. And I think it's appropriate at that time that if there is a resolution at that point, that the consent order has in it that the person acknowledges that they did something wrong under the act. I think we're in a different procedural posture at this time. I think that we're in a posture now that's more similar to a civil case that we may do. And we know that when we resolve a typical civil case, there's always a settlement agreement or some type of release or something that's drafted. And in that, it's always specified that each side holds their positions in place. The defendant in those cases always says, look, I'm not admitting that I'm liable. I'm just going forward with this agreement because it's the appropriate thing for me to do at this point. And the other side, the plaintiff side, continues to say, well, when I'm done, I still believe that you owe me, a certain amount of money. So that's how I distinguish where we are procedurally. Commissioner Thompson, I know you want to add something.
Well, I just wanted to comment on something Director Amati said. I don't think the commission's goal is to collect money. And maybe you didn't mean it that way, but I heard it that way. I don't think that's what, at least in my opinion, it's not about how big the civil penalty is. Because, as been discussed, the individual is not feeling any of that pain. Because it's not their money to do anything they want to with anyway. And I understand that the way the law is now, it allows for them to pay their civil penalties for campaign finance from those funds. But just transferring the money over, I don't think, should be our goal.
Thank you, Commissioner Thompson. Are there any other questions or comments at this point? All right, I will go ahead and make a motion that we accept the consent order as presented in the matter of John Oxendine, case number 2017-0169 PC, otherwise known as Oxendine 2.
I'm just second it.
All right, we've got a motion and a second. Is there any discussion? Hearing none, I'll go ahead and call the question. All in favor, say aye. Aye. Any opposed?
Aye.
Motion passes 4-1 with Commissioner Thompson voting against the matter. Again, I want to thank y'all very much for cordially working this matter out. Next on the agenda, we've got item number 4 for public comment. Is anyone here for purposes of public comment? All right, hearing none, we will move then to item number 5, which is adjournment. Do I hear a motion?
So moved.
Got a motion and a second. Is there any discussion? Hearing none, this special meeting of the Georgia Government Transparency and Campaign Finance Commission is adjourned.